Hello, welcome once again to Lehto's Law. I'm Steve Lehto. Today we're talking about a little bit of history here for you. I do this from time to time. I've mentioned before that as well as being an attorney and a writer, I also have studied history quite a bit, and I've got a degree in history, and I've written some books on history. So we're going to talk today about the United Auto Workers and the sit-down strike and their first contract. And it's one of these things where a lot of people know about the UAW, a lot of people know about unions, but there's something I think that's fascinating about the first contract signed by the UAW in 1937 that most people don't know. And when I tell it to people, they're really, it's interesting if nothing else. So just bear with me. I've mentioned unions before. I've talked about the Italian Hall disaster. It happened in 1913 in Michigan in the copper mines. There was a strike, and during that strike, there was the event called the Italian Hall disaster, where someone yelled fire in a crowded theater, and 73 people died in a stampede trying to get out of the building, and there was no fire. So that happened during a miners' strike, and the union that was trying to get recognition was the Western Federation of Miners. They did not get recognition, and in fact, that strike ended the next year, and the workers just came back to work, tore up their union cards, and went on. And so people have asked me, they said, Steve, did that strike actually accomplish anything as far as the workers go, or was it literally just a waste of time and a thing that created this situation where you could have the Italian Hall disaster happen? And I tell people, I said, well, there is one thing. It did start getting people to think about unions and also about the plight of the workers. And I'm not trying to sound like a communist organizer here, but there was a time when workplace conditions in America were not that good. So that in 1913, to go back to the mines, in the copper country of Michigan, which is basically a 3-county area, for a couple of years there, the death rate in the mines was they'd lose one man a week. One man per week would get killed in the mines. And at the time, if you got killed on the job, they would literally bring your body out and send a notice to your widow saying, get out of the company house. We have to give it to somebody who's not dead. And there was no workman's comp. And you couldn't sue the mines because they said, well, that was assumption of the risk. You knew how rough this job was and you took the job. And I know people right now are saying, well, Steve, you didn't have to take the job. But I think as a society, we've recognized that if you're going to hire people and pay them to work in your company, on your property, in a situation that you control, you've got to provide them some standards of safety. And so we have safer standards. Now, you can argue about whether or not the pendulum has swung too far to one side or not. That's another story. I know people who go nuts if you mention OSHA or MyOSHA or any of the different organizations that come in and check workplace conditions because sometimes they can be nitpicky. And I am willing to say that, yeah, there's a debate there about how much regulation you need. But you do need some regulation, okay? And that's why we still hear about situations where, a factory in Asia someplace will cave in and hundreds of people will die. And you go, wait, the building just caved in? And you're not sure, is that a worker condition problem or a factory problem or a local building code problem? Who knows? Who knows? But the point is, those things happen over there now. They don't happen here as much, okay? So you got to understand that the workers' strike in the copper mines was 1913 in Michigan. And it went the way most strikes went. That is that the people tried to organize. They organized to some extent. They called a strike, and they managed to shut the businesses down for a while. But the businesses had so much cash they were sitting on that they could just ride the strike out, which is what they did. The strike ends, and the thing about it is that the Italian Hall disaster actually drew a lot of attention to the strike on a national front. And it was around that time that people in Washington started talking about things like, age. How old can you be to work in a factory 12 hours a day, And so they started talking about child labor laws, for instance, and things of that nature. So some changes started gradually. And I'm not saying the Italian Hall disaster caused those changes, but it was one of the things that drew attention to the topic. So a few years later, a couple decades later, the automobile plants in Michigan primarily were going gangbusters, building cars. And this is right before World War II. And in 1935, they organized the United Auto Workers, a union organized and sought union recognition. And the plants, the companies would not recognize it. And it was fairly common at that time for companies to say, look, we'll individually negotiate with each and every one of our workers, but no one has the right to negotiate on behalf of all of them. And while that sounds logical at first blush, you have to realize that stockholders don't all negotiate one-on-one with anybody. They form a corporation and they elect somebody to speak for the corporation, which is actually a collective of stock owners, right? So many people have pointed out that the logic should apply to both sides. That is, that if the workers want to, they should be able to say, we appoint this person to speak for all of us. Now, the question is what the union can do beyond that if you don't recognize, or if you do recognize, but you won't negotiate in good faith. And so there would eventually become laws to protect unionization in America. But here's the thing. In 1936, when the UAW sought recognition at the plants in Michigan, the big corporations would have none of it. So on December 30th, 1936, in Flint, Michigan, the workers sat down. It was a sit-down strike. And they sat down on the job and just said, we're going to stop working, but we ain't leaving. Now, again, I know some people criticize this and they say, Steve, but they don't own the plant. They've got no right to do that. Well, I'm just telling you what happened, okay? And here's the point, is that the sit-down strike, when it happened, the corporation appealed to the governor and said, would you please send in the National Guard because we're worried there's going to be violence. And in previous episodes, both in Michigan and elsewhere, when the National Guard got called in, the National Guard is the state militia, so the Michigan National Guard, for instance. When the Michigan National Guard had been called into Calumet, they were called in to protect the mines. But the interesting thing is that in 1936 and then 1937, when the Michigan National Guard got involved, the governor told them, you're not on any side. You're not there to protect one side or the other side. You guys are merely a stabilizing force to stand there and make sure violence doesn't happen and to stop violence should it be threatened or should it actually happen. So the National Guard got there, showed up and said, okay, no violence. And I'm not saying there wasn't any violence, but I am saying that the management said, wait a second, you're not going to go into the factory and haul those people out? National Guard said, that's not our job. That's not our plant either. And the people at the corporations, General Motors, got very upset and started, petitioning and campaigning and asking various people, like, what are you going to do for us? And the UAW just said, if you simply negotiate with us in good faith and recognize us as a union, we can stop this nonsense right now. And I know at one point in time, both sides ran to court to get injunctions and restraining orders, but the strike made it to about February 11th. So it made it 45 days, 44 days, something like that. And the General Motors finally said, something, we'll just negotiate. We'll recognize the union and we'll negotiate. Now, much of what I've just told you, you've probably heard if you've known the story about the sit-down strike or the UAW being formed. But what I've always found fascinating, and when I taught Michigan history at the college level, I would tell my students, by the way, I'm now going to hand out to you a copy of that contract. And if you've seen a recent UAW contract, which I doubt, but you can look them up online now, they routinely run 600 or 700 pages in length. Times change. The original UAW contract was one page, and this is the entire text of it right here. Now, I've got a copy of it here. It's been reduced, and it's set in some funky type. It's kind of hard to read. I got to put on my smart glasses. But I can tell you that the first UAW General Motors agreement was entered into February 11th, 1937. And I'm going to read to you not the whole text, but the bulk of it, because you're going to see what it started out as was simply something very, very simple. The agreement entered into on this 11th day of February 1937 between the General Motors Corporation and the International Union United Automobile Workers of America, hereinafter referred to as the Union. Corporation recognizes the union as a collective bargaining agency for those employees of the corporation who are members of the union. Paragraph 1, we just recognize the union. That's it. Number 2, the corporation and the union agree to commence collective bargaining negotiations on February 16th with regard to the issues specified in the letter, and they're basically going to negotiate in good faith. 3, the union agrees to forthwith terminate the present strike. Strike's over. 4, the corporation agrees that all its plants which are on strike or otherwise idle shall resume operations as rapidly as possible. Strike is over. We're getting back to work. 5. It is understood that all employees now on strike or otherwise idle will return to their usual work when called, and that no discrimination shall be made or prejudice is exercised against any of them because of their affiliation with or activities in the union or the strike. So, we recognize the union. Strike is over. We're going to negotiate. We're opening the plants. We're going back to work. And we're not going to discriminate against people because they were in the union or involved in the strike. And then the union agrees that pending the negotiations referred to in paragraph 2, there shall be no strikes called or any other interruption to or interference with production by the union's members. So we're going to negotiate in good faith. During the existence of the collective bargaining agreement contemplated here, all opportunities to achieve a satisfactory settlement shall be exhausted before there should be any strikes. So, in other words, we're just going to negotiate and we're going to continue working while we negotiate until we've actually said we can't negotiate anymore. And I know people out there who say, Steve, for the workers to act like they own the factory is wrong. Well, they're basically saying, no, look, we own the labor. We own us. And they're saying the corporation doesn't call on all its stockholders to negotiate something. They got one guy who does it. Why can't all the workers have one guy who goes and talks to that person? And it's just a one-on-one. It makes sense. And so the interesting thing, though, in this single-page document is that they said, look, it's simple. Recognize the union, and we're going to negotiate in good faith. And as long as we're negotiating, we're going to keep working. We'll keep working. You keep the plant open. We're negotiating. And you have to understand that before this happened, in America, if a company had enough money, the second they heard wind of a strike or wind of a union or wind of some, they'd bring in strike breakers. They'd lock down the plant. They'd beat up the strikers. And it's like, wouldn't it be better if we talked instead of beat each other up? And that's actually what this is saying. I mean, I know it's a novel concept. It was at the time. After the evacuation of its plants and the termination of the strike, the corporation agrees to consent to the entry of orders dismissing the injunctions. So they basically say at the very end, and by the way, all legal actions are going to stop. We're not going to take this to court and have a court settle it. We're going to settle it. Like grown-ups, sit down and talk, as opposed to the stuff we used to have. Now, I said before, I talked about the pendulum, and that's an image that a lot of people use. And they'll say a pendulum can swing both ways. And so we had abuses in a workplace that were horrific by today's standards prior to 1914. And as I told you, one person dying a week in the mines and 10 people probably every week getting maimed in the mines. People losing arms and legs and being blinded, losing your eyesight. And they say, oh, you can't work anymore? You can't work here, you're missing an arm. Yeah, I lost the arm back in the mine. Sorry, you knew that was the risk when you took the job. So things have gotten better. And here's the problem we often have, and I'm lecturing you young folk, is that generations often don't know what the prior generation went through until they study it or they're told about it. So it's very, very hard for us to imagine what it was like on D-Day to storm Normandy Beach, okay? I wouldn't be born for 20 more years, at least. But if you talk to somebody who was there, and they describe it to you, and if you actually absorb it, you understand, oh my gosh, what these people went through on that day. Normandy Beach, right? Or if you talk to somebody who worked in the mines back in the day, I've talked to people who worked in the mines, and they talk about how the times changed, how they started out in a situation where, people just died. It was not uncommon. People did haul a body out of the mine, another day in the mines. And nowadays, when somebody dies in a plant, it makes the news. And by news, I mean they'll actually, big deal, somebody just got killed in the plant. Back then, it would make the news, and I'm not making this up, there'd be a one sentence, sometimes a half a sentence, buried in a deeper story to say a Finlander died in the mines yesterday. Might not say which mine, might not say what his name was, all it says is a Finlander died. And as you can imagine, those are my people. So when a Finlander dies, catches my attention, but it wouldn't catch many other people's attention, especially because it wouldn't give a person's name. And so times change. And I will grant you that the unions, which started here, would just recognize us and talk to us in good faith. it's swung quite a way. And I'll agree that they had some abuses, like the jobs banks and so on, where they actually said, we'll pay you to sit in a room. Um, most people can't even wrap their head around that, other than if I can get that job, I'd take it. But other than that, it's like, it doesn't make any sense. So I'm not saying that all unions are good or that all unions should be preserved or that, unions can do nothing but good. But I'm simply pointing out that you have to go back to an earlier time to understand what it was all about and why they got formed. But, like I said, if nothing else but as a historical footnote, okay, you should know the first UAW contract, single page, very little legalese, somebody with a decent 6th grade education could actually read it and understand it. And it's actually a monument to contract drafting. I would actually suggest that they should show this to people in law school and say, by the way, you understand that the United Auto Workers, the union that it is, was started by a single document written this simply. So that's another point as well. But I'd like to point out, like I said, the first contract between the UAW and a manufacturer of automobiles, General Motors, was a single page document, which I find fascinating. I hope you do too. Questions or comments, put them below. Let's talk to you later. Bye-bye.